Hi, I'm Nirmal, and today we discuss about the legal environment of business. So, legal environment act as an important factor for setting up or running any business activities by an individual or any organizations in a particular country. The legal environment in one country is different from another country. Legal environment decides the way of how business activities of any particular country are able to flourish or may get constrained by the laws of the nation. It also influences in estimating the useful economic life of an tangible asset. The components of the legal environment and how it affects any business is further discussed in these articles. So, what is legal environment of business? First, we have to know this. The term legal environment of a business refers to a strategy adopted by any government to help manage or constrain the business of the country. Legal environment of a business includes various legislations enacted, amended, or repealed by the government, administrative orders proclaimed by government authorities, decisions issued by various commissioner or agencies of the central or state or local government, as well as judicial activities. And the legal environment in India includes various laws regulating business activities like Companies Act 2013, Consumer Protection Act 2019, and many other such legislations policies relating to licensing and approval, foreign trade, etc. In every country, the government frames its legal systems according to its definite purpose and properties in order to regulate the business ecosystem of the country. The government may also limit the business activities by regulations. These factors in turn create the legal environment of a business. The legal environment of a business indicate a twofold purpose set by the government which helps the business to flourish, which in turn benefits the citizens either by generation of employment or by any services. In negative connotations, the legal environment, especially in social or mixed economics, may constrain or hinder the growth of the business. So now we discuss about the different aspects of legal environment. Rather than simple compliance with the law of the land, the legal environment of business also implies understanding the legal frameworks which dictate the business operations. The various laws that comprise the legal environment of a business are discussed right now. So, antitrust law. Antitrust law is also known as competition law. It promotes or seeks to maintain competitions for regulations of the anti competitive conduct of the companies. Anti competitive behavior by companies includes monopoly or oligopoly, which imply an imperfect market structure. Companies agree between each other and they will act unethically and not in the favor of the consumers. Antitrust law is also known as anti monopoly law in China and Russia. Antitrust law is aimed to provide fair competition in the market so customer will not be in disadvantageous position. So monopoly, what is monopoly? The practice of monopoly is when a particular business organization dominates a particular industry by excluding all other potential competitors. Following are the way through which a business organizations may establish monopoly in a particular business area. So mergers and acquisitions. A company may have a lot of mergers and acquisitions. As a result, it can be the only one that provides one particular product in the market. A natural increase in the prices of the product. Oligopoly refers to the uncompetitive practices between the business organizations or firms which several of them agree to increase prices artificially altogether. It violates the antitrust law. Hence, the regulations of the antitrust law also helps to keep these situations in control. Implications for monopolies for consumers. Monopoly can also be good or bad. Good monopoly provides lower prices and new product being the only one in the market and it acts in the benefit of the customer. There might be a bad monopoly when there are higher prices, limited choices, less investment on new products, etc. It does not provide any diversity for the customer. Antitrust legislations and policies also prevent unfair prices discriminations amongst consumers. Antitrust laws in India. The very first antitrust law in India was the Monopoly and Restrictive Trade Practices Act 1969 to restrict monopolistic practices in the market. It was repealed in 2009 and subsequently was replaced the Competition Act, that is 2002. Under this act, the Competition Commission of India was established to prevent anti-competitive business activities in India. Environmental protection laws. Environmental protection laws are formulated in order to save the deteriorations of the environment from the unlawful activities of human beings. Regulations on the environment impact the business directly or indirectly. On the other hand, it also ensures that the environment is not affected by the business. Stringent environment protection laws may force the business organizations to change their business operations and activities or to relocate to another place with less stringent environment regulations. However, there is a twofold effect of these environment laws in businesses, or business might get carried away with less stringent laws in place. Environmental protection laws priorities saving the government and the business organizations need to adjust with the regulations. In pollutions and energy intensive sector, the environmental protection laws may cause reduced employment and productivity. There is hardly any possibility of huge negative effects of environmental regulations on business. However, for highly polluting industries, the possibility of effects of environmental regulations cannot be ruled out. The moderate benefits of environmental protections laws largely outweigh the so-called losses in the business operations of activities. Compliance to environmental protection laws. Compliance to the existing environmental protection laws of a particular country requires the business protection organizations to execute the following actions. Environmental auditing. Environmental auditing is used to assess the impacts of business activities and operations on the environmental against set criteria or standard. An environmental audit helps in identification to reduce impact of business on the environment, prioritize sustainable business activities and demonstrate accountability to government, customers and shareholders and concerns for the government. India is the very first country to make environmental auditing in industrial units compulsory. The concepts of environmental auditing in India was first formally introduced in the 1992. The Supreme Audit Institutions SAI SAI in India is headed by the Comptroller and Audit General, that is CAG, Auditor General. So Comptroller and Auditor General CAG of India perform environmental auditing in India. Setting up an environmental management system. Some business may require to set up an environmental management systems for the following subjects and targets of the business by mean of protection of the environment, finding out the impact of the business on the environment, practicing environmental sustainability, figuring out responsibilities to protect the environment and running the businesses, and identification of the business areas of improvement. Proper monitoring and reporting on impact of the environment. For most of the businesses, the monitoring and reporting the impacts of the businesses on the environment is not mandatory. But for some energy intensive industry sectors, the monitoring and the reporting includes the following levels of carbon and greenhouse gas emissions, level of waste materials and dispose the water bodies, and triple bottom line reporting. This includes evaluation in social and environmental and financial framework, compliance to government requirements. Many countries have administered their own environment protection laws. How this will affect the business depends upon the type of nature of the business. Some businesses also may require licensing and permission from the government. Environment protection laws in India, the environmental consequences and ethics of Indian civilizations traces back to the ancient Vedic era. The same ethics is also followed in modern age while framing act and regulation regarding the protection of environment. India has 6 major laws related to the protection of the environment as a whole and the protection of the components of it. These includes the Environmental Protection Act, that is 1986, the Forest Conservation Act 1980, the Wildlife Protection Act 1972, Water Prevention and Control of Pollution Act 1974, Air Prevention of Control of Pollution Act 1981, and the Indian Forest Act 1927. The Green Tribunal formed under the National Green Tribunal Act 2010 in 2010 supervises the cause relating to the environmental in India. Labor laws. Labor law mediates the relationship between the government and employees and trade unions. Labor laws ensures that the following rights of the employees are properly protected. Minimum wages. The minimum wage is the lowest amount which the employers should pay their employees. Each country around the world has a fixed minimum wages set by the labor law. The employer are required to take any into considerations that they should agree to pay minimum wages to any employee and should not exploit by paying less than that amount. Fixed working hours. The international standard working hours for a full-time employee is 8 hours, 5 days per week, and a total 40 working hour a day. Many countries have their own set standard of working hours which the business organizations need to comply with. If a person works more than the mentioned hour which are not written in the contract, the employer is bound to pay overtime for that particular employee for working more. So section 51 of the Factories Act 1948 provides that no worker should be allowed to work more than 48 hours in a week. Public holidays in Labor Act or labor laws, it is strictly mentioned how employer and employee should act during the public holidays. During public holidays, an employee usually has a day off and the employer can only invite the employees for overtime. The weekly holidays in India are governed by section 52 of the Factories Act 1948 as well as by the Weekly Holidays Act 1942. So maternity leave benefits. With more women joining the workforce, the need for maternity leave arose prominently during the 1970s internationally. In case of female employees, labor law mandates them to provide maternity leave with payment during and after the birth of a child for a particular time. After that period, maternity leave may still be available but without payments. The stipulated during of a maternity leave varies from country to country. This ensures to security of a mother job and proper care for the infant. In India, maternity leave benefits are governed by the Maternity Benefit Amendment Act, that is 2017's workplace discriminations. There are the other factors that the labor law supervises. Anti-discrimination laws offers protection against any discrimination based on race, class, creed, caste or gender. Currently, India lack of exhaustive legislation on anti-discrimination laws, which can cover up a broad dimensions. India has a few different laws dealing with specialized protection against discriminations in any particular case. The anti-discrimination laws in India includes the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, and also known as POSCO at Work Act 2013. Others protection to women from the events of sexual harassment in workplace. The Right of Persons with Disabilities Act 2016 for safeguards the rights of persons with disabilities including workplace. The Human Immunodeficiency Virus and Acquired Immunodeficiency Syndromes Prevention Act, Control Act 2017, also known as HIV AIDS Act 2017, which includes the rights of the infected person against discrimination at workflows. The Transgender Persons Protection of Rights Act 2019 for protection of transgender persons for discrimination even at workplace. Further, any discrimination based on religion is a criminal offense under sections 153A of the Indian Penal Code 1860. The Industrial Disputes Act 1947 prohibits commissions of certain unfair labor practices which offers protection against discrimination and showing favoritism or particular to any individual or a group of worker regardless of merit. Labor law in India, apart from these pieces of legislation mentioned, India has a long list of labor laws to protect the employee. Many activities by the various trade unions have also contributed to it. It is impossible to put all the legislation here for the paucity of space. So the concerned pieces of legislation can be found from the official websites of central government under the Ministry of Labor and Employment. So thanks a lot for watching my videos, and as I always says or requesting to you that if you like my MBA channel, please subscribe my channel, also comment and share my channel, and please press the bell icon for my updating videos. So once again, thanks for your time for watching my videos. I need your support, my friends. Please subscribe my channel. Thanks a lot.